Welcome to the third edition of our Knowledge Series 2020 and our final destination in our emerging market segment here, or virtually here in Lagos. We have 3 more destinations to come and you'll hear about those again. But as many of you know, because many of you have come back to join us again for Knowledge Series, our first 2 editions were in Mumbai and Riyadh, and they were great successes. For those of you who are joining us for the first time, please know that this is a free flow discussion amongst our insightful, highly experienced and knowledgeable panelists. We also describe our series as an open dialogue. That means that we strongly encourage your views, and Rachel will take you through the opportunities that you have to provide questions to our panelists. And the dialogue will remain open as we travel around the globe. So here we are, virtually in Lagos. Why are we here? Why have we chosen Lagos? Specifically, it's because Africa is one of the biggest emerging markets in the world, offering tremendous opportunities for companies brave enough to seize them. And right now, these appear to be the tech companies. And technology is at the heart of what we're doing, or the themes that we're exploring with the Knowledge Series. In the World Bank's Ease of Doing Business Report 2020, Nigeria was in the top 10 economies that improved the most on the ease of doing business. It is 131 out of 190 on that league table. Relevantly to our discussion today, Nigeria improved by making reforms in 6 critical areas, one of them being enforcing contracts, which means the time and cost to resolve a commercial dispute and the quality of judicial processes for men and women. That is another theme that we'll be exploring today as the panelists take us through the various jurisdictions, what they see in their experiences, challenges and opportunities. And technology, just some technology facts from and about Africa. Among the world's 30 fastest growing cities, 21 are in Africa. The Twitter CEO, Jack Dorsey, has predicted that Africa will define Bitcoin's future. The number of active tech hubs in Africa has almost doubled over the past few years, from 314 in 2016 to 618 in 2019. And Nigeria has the greatest concentration of those tech hubs. So as you can see, this is fertile ground for this tremendous conversation that you're about to hear with these amazing panelists. And again, we welcome you to this session and please interact with us. Rachel, thanks very much. Over to you to introduce yourself, of course, and the panelists.
Thank you so much, Linda. That was a fabulous introduction and a really good overview of the Nigerian market. As Linda mentioned, this is the 3rd event for the Knowledge Series 2020, and it's our 2nd webinar, and we're really excited to have you all with us today. Linda is the CEO of the Abu Dhabi Global Market Arbitration Centre and one of the key partners for this event, so we thank them for the support. And I'd also like to thank Phoenix Advisors for their support as well, and we'll be hearing from Dilip in just a bit. As Linda mentioned, this really is a conversation, so we want you to engage as much as possible. We had a really great interactive session on our last webinar, and we hope that we repeat that this time around. And on that note, I would actually like to ask the first polling question, just so that we get a sense of who our audience members are and what sort of experience that you have in Africa. So the first polling question, are you currently working or working with clients on business or legal matters in Africa? Now, just another quick housekeeping point before we start. We do really want to hear from you throughout the session. We have a chat functionality and a Q&A functionality. We ask that you please use the Q&A functionality only, because otherwise there's just so many sources for us to check, and we really don't want any questions to go left unanswered. Okay, so the answers are coming in, and it looks as though almost half of you are currently working or currently working yourselves or working with clients on business or legal matters in Africa. So we do have a fair amount of experience from our audience, which is great. Now, before I hand over to the speakers, I would just like to introduce our wonderful panelists today. We have Isaiah Bazimo, who's a partner at Broderick Bazimo and Company. We have Dilip Masand, who's a founder and CEO at Phoenix Advisors. We have Nedi Weke, who's an international trade partner at Aiken Gump. And we have Tom Snyder, who's a partner and head of arbitration at Al-Tamimi. So I'd just like to get each panelist to briefly introduce themselves, and we'll go in alphabetical order so there's no arguments. Isaiah, can you please introduce yourselves for the audience?
Rachel, thank you very much. It's a pleasure to be here with you all. My name is Isaiah Bazimo, as Rachel said. I'm a partner in the firm of Broderick Bazimo and Company. We are a niche disputes firm here in Nigeria. And we have a lot of matters in the courts and in commercial arbitration. And I very much look forward to the discussions that we'll have today.
Great, thanks so much, Isaiah. Dilip, please go next.
Sure, thank you, Rachel. Hi, I'm Dilip Masand. I am, as Rachel said, the co-founder and CEO of Phoenix Advisors. We are primarily a litigation funder based in Abu Dhabi with a keen eye on Africa, India, and the Middle East. And very happy to be working on the Knowledge Series with ADGM Arbitration Center and Rachel, and welcome to our panelists and the audience.
Thank you, Dilip. And Neddy, we have a very special guest from Washington, D.C. So thank you for joining us early morning your time, Neddy. And please introduce yourselves to the audience.
So good morning, good afternoon, good evening, wherever you may be. My name is Neddy Ifudunweke. As Rachel said, I'm a partner in the law firm of Aiken Gump, Strauss Hauer Feld. I am in the lovely Washington, D.C. I counsel clients on various U.S. trade laws that affect cross-border movement of goods and services. I focus on sanctions, export controls, anti-corruption, and anti-money laundering laws. And I believe that I've been invited to join the panel because I work with U.S. and non-U.S. investors who are interested in investing in sub-Saharan Africa. So thank you for having me.
Thanks, Neddy. And last but not least, Tom.
Thank you, Rachel, and good afternoon, everybody. It's a real pleasure to take part in this. As Rachel said, my name is Tom Snyder. I'm a partner and the head of arbitration at Al-Tamimi and Company based in Dubai. I've been doing work in Africa for almost 2 decades now. As a young lawyer in 2001, I went off to Ethiopia from Washington, D.C., where I was living at the time, to represent the Ethiopian government in a couple of arbitrations. Ended up living there for 3 years and have been doing work on the continent ever since.
Excellent. Thanks very much, Tom. So as you can see, we have a real breadth and depth of experience from our panelists, both outside looking into Nigeria and Africa and also on the ground. So while this discussion is focused on Nigeria, we'll start off by taking a broader look at the African continent. But before we do so, I would just like to check that you're staying engaged and would like to do the next polling question. So this is, what do you or your clients consider to be the most significant factor in deciding whether to select an African jurisdiction for resolution of disputes? Is it transparency, efficiency, progressive legislative and regulatory framework, or ease of enforcement of judgments? So our panelists today really do have an international client base, and we'll be hearing from them about their client views on doing business in Africa. It looks as though, as the answers are coming in, once again, we have quite a sort of clear winner, and that is the most significant factor is the ease of enforcement of judgments. And we'll be touching on some of these points as we go along. Okay, Tom, now you are, you've been working very closely, and you've just mentioned that you went out to Ethiopia almost 20 years ago now. How would you compare some of the jurisdictions across Africa in terms of the current state of dispute resolution?
Yeah, I think that's a really interesting question. I think the first thing I would say is that we're seeing a lot of really good progress across the board. I think the danger of singling out a few jurisdictions is that you inevitably leave some off the list, and there may be some that I should be including. But I think if you step back and look at developments, especially from an arbitration perspective, there are a few jurisdictions that stand out. And I think you need to look at key factors such as has the jurisdiction adopted the New York Convention? Does the jurisdiction have an arbitration law that is based on the UNCITRAL model law? Are there reliable arbitral institutions in the jurisdiction? And probably last, but certainly not least, and I think our poll suggests maybe the most important factor is what are the courts like in that jurisdiction? Are they arbitration friendly? Are they enforcement friendly? I think with those factors in mind, some of the jurisdictions you have to take notice of are jurisdictions like Mauritius, which has really made a sustained effort, I would say really for the last 12 or 15 years now, to hold itself out as a reliable go-to jurisdiction for dispute resolution. I think others are Rwanda. It's ratified the New York Convention that has a arbitration law based on the UNCITRAL model law. The Kigali International Arbitration Center has been really active. You have to look, I think, as well at Egypt. Egypt is an interesting jurisdiction with 1 foot in Africa, 1 foot in the Middle East. But it has really, in the past several years, made an effort to reach out to Africa more generally and try to establish itself, I think, effectively as a seat for arbitrations involving African parties. I think 2 other jurisdictions are your common law jurisdictions, Nigeria, Kenya. There have been a lot of developments there. Maybe some challenges with the courts, and I think Isaiah might address some of those issues in further detail in a little bit. And probably one other jurisdiction that I would keep my eye on, maybe 2 more. One is Morocco in North Africa, and one is Ethiopia. I think I'm a little bit biased, but I think a real positive development there is that Ethiopia has now, is in the process of ratifying the New York Convention, and I think that's one to watch.
Fabulous. Thanks very much, Tom. And yes, we'll certainly come back to those points on common law as well. Nettie, you're based in Washington, D.C. What's your experience with clients looking to invest or do business in Africa? Do they prefer one jurisdiction over the other? And perhaps you can discuss some of the ones that Tom mentioned. And also linking back to what the audience said, that their key concern was often ease of enforcement of judgments. Could you please give your views on that as well?
Yeah, so obviously the motivations for investing or doing business in Africa and selection of jurisdiction will vary from client to client. However, common themes are, number one, identifying a commercial opportunity, which they think will be profitable and where their investment and expertise will make a difference. And then you look for relative legal, economic, and political stability and a decent infrastructure, right? But as it relates to the legal stability, you find US, UK investors generally inclined to invest in common law jurisdictions. In addition to the key determinants, which I just mentioned, jurisdictions for investment are also very much driven by the size of the available market, right? So for businesses that are domestically focused, if there's a sizable market, regardless of the other determinants that I just mentioned, that may be an attraction for investment. There's also familiarity with language, like I said, the legal system and culture, right? All of these play a big role. So US and UK investors tend to favor English-speaking countries, while you find the French companies generally more inclined to invest in Francophone Africa. But of course, this is not exclusive, right? The sheer size and attractiveness of a market will sometimes trump the desire to be in a familiar legal system. So you have French companies, for example, investing in Nigeria and South Africa. In fact, I heard recently that Orange, the French telco, is now making inroads in Nigeria. So notwithstanding the desire for a familiar legal system, ease of enforcement of judgments, sometimes the nature of the investment and the attractiveness of the opportunity will overcome these other factors.
Excellent. Thanks, Nettie. And Isaiah, you're actually on the ground in Nigeria. Do you have anything to comment on the statements made by the panelists on the familiarity and the common law? And then maybe also talk us through some of the changes that you've been seeing on the ground there recently.
Rachel, thank you very much. Let me start with the effect of what we've been seeing recently, and I'll touch on briefly on what Tom and Nettie have said concerning their client preferences. I think inevitably COVID-19 has affected what the reality is on the ground, and as with many jurisdictions, that effect has been both immediate and severe. Immediate in the sense that the government was very quick to put in place restrictions to curb the spread of the virus. And those restrictions included the suspension of court sittings. And severe in the sense that we're seeing data from the National Bureau of Statistics that 42% of those surveyed had ceased work on account of COVID-19. And 78% of those respondents had reported a drop in total household incomes. And you could see the relationship this would have on the economy as a whole. So for instance, a decrease in spending power impacts the revenues of businesses, particularly those MSMEs that form about 50% of Nigerian GDP in nominal terms and account for about 84% of all Nigerian workers. And in turn, those businesses default on their obligations. So cumulatively, what we've been seeing is that there's been a surge in vulnerabilities, which has led to a surge in legal needs. But there's this vicious circle where those legal needs are unable to be serviced because the courts have suspended sittings. And to put it in context, there was a report that about 150,000 cases have come to a standstill on account of COVID-19. So naturally, the situation was ripe for a transition of courts from in-person hearings to remote hearings, and a number of courts have indeed done so. In the case of Lagos, the first remote hearing was held on the 4th of May, just under 2 months ago. And many other courts have followed suit and have issued practice directions on electronic exchange of documents and electronic hearing of cases. But what we're finding, interestingly, is that that transition has in and of itself thrown up a constitutional debate. And what I'm noticing is that sometimes opinions are as problematic as the virus itself. The argument there is that remote hearings are unconstitutional because there's a provision in the Nigerian Constitution under Section 36(3) that mandates all court hearings to be held publicly. So really that argument rests on the proposition that where hearings are online, then they are not public. Well, I disagree with that, and thankfully a lot of practitioners also disagree with that because it overlooks the fundamental rationale of a public hearing on the Nigerian law. So it serves three purposes for me. It serves transparency, accountability, and fairness. So in other words, the public benefits from seeing how the justice system works in a public hearing. And lawyers and judges, conversely, have an increased incentive to uphold their ethical duties, knowing that the public is watching them. And from a sheer numbers perspective, let me just give a brief comparison. The largest court in Nigeria can probably take, in a generous estimate, probably 1,000 people. Whereas estimated 85 million people have access to the internet. So from a sheer numbers perspective, it would seem that online hearings conducted remotely are more public in the sense that the public, a large proportion of the public can have access to them than they would in in-person physical hearings within the courts. In terms of comments expressed by Nettie in particular, I would say yes, that the majority of investors tend to come from common law jurisdictions, given the familiarity of the legal system. But that said, some of the biggest investors are from civil law jurisdictions, and not to mention any names, but there are major investors from Germany, for instance, France, as Neddy mentioned. And I think the investment space is becoming pretty much agnostic in the sense that even companies from the civil law jurisdictions are willing to come and invest in Nigeria and invest on the continent. And that might have to do with the implementation of the Continental Free Trade Agreement, which is coming on stream pretty soon. But in general, also the attractiveness of the investment climate. So I'll pause here for now, and given time, but I'll be happy to take any further questions that will come my way.
I just had a quick question on one of the number you mentioned, Isaiah, when you said 150,000 court cases currently suspended because of the pandemic. Can you put that in context? So, for example, how many would you maybe see going through the system, every month or something? Right.
So it varies from state to state. So Lagos State, which is a very commercial jurisdiction, at one stage had about 10,000 commercial cases filed each month. Other cases, of course, the number is much lower. So that figure of 150,000 was a cumulative sort of collation of the cases pending at the High Court level across the 36 states and across the appellate courts, so the Court of Appeal and the Supreme Court as well.
Great, thank you so much. And you mentioned another number as well, the 78% of households that have been impacted in terms of spending and the knock-on effects to SMEs as well. I'd like to slightly pick up on that, but change gear. One of the knock-on effects of COVID-19 has definitely been on liquidity and cash flows of clients and companies. And one thing that this could potentially give rise to is third-party funding or financial intermediaries. I would like to hand over to Dilip to give his views on this, but firstly, I'd like to ask another question to the audience. Yes, when we said we were going to engage you, we really did mean it. So have you been involved in a case involving African parties or an African dispute where one of the parties had third-party funding, i.e. as a funded party or as a counsel arbitrator in a case involving a funded party? And I know that this discussion came up quite a bit in our Mumbai version of Knowledge Series. And so it would be quite interesting to see how it compares with Nigeria, our other emerging market focus.
Thank you, Rachel, for that handoff. That being said, I will say, listening to Linda and Isaiah, I am now thinking that maybe we need to start looking for legal tech opportunities in Nigeria and come up with an online dispute resolution system and maybe put some money into that while we're still building the opportunity for litigation funding. In terms of COVID-19 and the lack of liquidity, maybe globally, it's interesting. I would say that you have two types of funders. You have the international funders who would look at Africa, who are mostly based in London, and they would follow the path that common law jurisdictions were created out of the British Empire. So prior to COVID-19, I think there was a lot of interest in the emerging markets because, frankly, there's a lot of money and capital in the litigation funding world, and you have a group of concentrated funders in the same jurisdictions. So Africa was very much on the radar. Plus, you've also had historically a lot of international commercial arbitration cases that come out of Africa that end up in London or in the ICC. So funders, international funders, are very used to seeing disputes involving African parties. That being said, though, in terms of domestic claims, it certainly is a nascent market. But I have done some research lately and come to learn that there's a bit of an ad hoc litigation funding market on the ground in Africa. And you will see that in Ghana, you'll see that in Nigeria. South Africa actually has a fairly established domestic litigation funding market. I think in terms of COVID-19, what we're going to see, like every market in the world, we are going to see liquidity issues. Isaiah talked about some of those. that creates opportunity for, or that creates greater disputes, which in turn need funding. That opportunity in Africa, though, I think the first movers are going to be those people who are already on the ground in Africa and understand the local context. I think it's going to be difficult for the international players, particularly now with COVID-19. You know, we talked about issues of enforcement. When you are looking at a case to fund and you're looking at enforcement, you have to exercise an asset recovery or investigations. Investigations on the ground have become very difficult due to COVID-19 for international funders or international asset recovery experts. So again, I think that the opportunity clearly is there. I think, frankly, the first movers will be the people on the ground. And the international funders are a little bit probably consumed with what is going on in their own backyards and looking at the very large commercial litigation cases as opposed to opportunities on the ground in Nigeria or in any of the African countries.
Thanks, Dilip. And yeah, the sort of issues around enforcement do seem to keep coming up again and again. So 51% of our audience have done business in Africa, but we had an overwhelming number, or 86%, had not been involved in a case involving litigation funding. Tom, in your view, have your African clients been receptive to the idea, and maybe discuss some of the points that Dilip raised about enforceability as well?
Yeah, sure. So I think there's a lot of interest in third-party funding, but I think it's still in its early stages. And I've seen the interest at various different levels. I've had African clients that were interested in getting third-party funding for their disputes in the Middle East. I've had intra-Africa clients, African client, African dispute, African counterparty. And obviously, interest among investors going into Africa, seeking third-party funding for their dispute. But as Dilip alluded to, I think this is still very much a developing industry, especially in regions like Africa, like the Middle East. I think there are a lot of opportunities. I think it will, just as it has in other parts of the world, become it won't be too long before it becomes common, prevalent in international dispute resolution involving Africa. And I think it'll be a game changer in many respects. I think it will provide a lot of opportunities to claimants with good claims who otherwise might not be in a financial position to pursue those claims. I think on the flip side, there is some, certainly based on some discussions I've had, there is some reticence or uncertainty about third-party funding. I think especially when you talk to government officials, attorney generals, ministers of justice, people in those ministries, some concern that third-party funding is going to open up the floodgates, and states in particular are going to be inundated with claims. I certainly see where they're coming from. I see why there is that concern. My own view is that the concern is probably a bit misplaced. I think when you are seeking funding, there is money to be had, but funders aren't just throwing money around at any dispute that comes their way. There's a tremendous amount of due diligence that goes into the process, and I think the system will weed out a lot of those non-meritorious claims. So I think there is some uncertainty, but I think there's a lot of opportunity for Africa when it comes to third-party funding.
Fabulous. Thanks, Tom. And Isaiah, on the ground in Africa, are you seeing much debate on the continent with regards to this? And are you seeing reticence and concerns regarding third-party funding?
So as Tom mentioned, the discussion is really still at a very early stage. I don't know of any funded cases yet. Speaking to colleagues, some colleagues have told me that they know of at least 2 funded cases within the African continent. And from the uncertainty perspective, I can tell you what Nigeria is trying to do to address that. So there's a current arbitration and mediation bill before the National Assembly, which actually provides express provisions on third-party funding, the most significant of which is the abolition of the torts of shambati and maintenance. So from a certainty perspective, a funder can fund a claim in Nigeria knowing that that claim doesn't have an enforcement risk, solely on the basis that it illegally funded a party. In terms of the discussions, they are happening. There is no structured discussion yet. It's still very much anecdotal. I know, personally speaking, of a couple of groups, and Dilip, this might interest you, that are thinking of setting up funding companies. But I think as laws liberalize and the discussion picks up and institutions show more of an interest in funding African claims, then yes, the debate will pick up. And inevitably, you will find more discussions going on across the continent. But at the moment, it's still at the very, very early stages, so that the debate hasn't picked up yet.
I think, and to your point, Isaiah, therein lies the opportunity, that it is early stage, so there's an opportunity for first mover advantage. One thing I wanted to share with you in doing a little homework on the Nigerian environment, we also saw that in the new Arbitration and Conciliation Act, you're allowed to recover costs, and among those costs are third-party funding. So funders are looking at that going, okay, we've got some statutory progress, and in your case law, though, from what I understand, and correct me if I'm wrong, lawyers are not allowed to work on success fees or contingencies. However, in exceptional cases, lawyers can advance legal fees on behalf of the client for convenience or hardship or et cetera. So, we're looking at these iterative developments and keeping our eye particularly on Nigeria, which is a very large, very active commercial market.
Yeah, Dilip, you're absolutely correct. Sorry, Rachel, just to speak to one quick point. Yeah, you're absolutely correct in that the legislation does provide for the ability to recover the costs of third-party fundings. And I think cumulatively, when you look at all these provisions, it does provide the certainty and the opportunity that funders are looking for.
Great, thanks for all those comments. I was actually just about to move on to the dispute resolution in Nigeria and comparing litigation versus arbitration or mediation. And very conveniently, we've actually had some questions come in from the audience on these topics. So I'd like to take some questions from the audience. We have one from Peter Phillips. Have any African jurisdictions developed a reliable infrastructure to support commercial mediation? Has non-adjudicative business dispute resolution been advocated by transnational investors and by courts? Who would like to go first on that one?
Pete, thank you very much for that question. So interestingly, the arbitration and mediation bill, which is currently before the Nigerian National Assembly, is looking to provide a structured framework for commercial mediation in Nigeria and to implement the provisions of the Singapore Convention. I'll talk a little bit more further down the line on initiatives that both the executive and the judiciary have taken in support of mediation. But in direct answer to your question, there are moves to provide a formal structure for commercial mediation. And I know institutions such as the Lagos Court of Arbitration and the Lagos Chamber of Commerce International Arbitration Center have commercial mediation rules as well that parties can take advantage of. I hope that answers your question. If not, please feel free to throw another one my way.
Excellent. Thanks for that, Isaiah. And yes, Peter, if you feel that was not thoroughly answered, please do just leave another question in the Q&A section. We have another question from Sean Gibbs, which is related to dispute resolution in Africa. And that question is, has anyone experience of parties using adjudication to resolve construction disputes in Africa outside of South Africa?
Speaking from a Nigerian perspective, I haven't seen that. So construction disputes in Nigeria tend to go to commercial arbitration. Again, there was talk of introducing an adjudication framework, but that hasn't picked up pace yet. I think colleagues, if any of our colleagues are in the audience from Kenya, I think Kenya has a pretty sophisticated adjudication framework, and they might be able to speak better to that point. But from Nigeria, the majority of construction disputes go to commercial arbitration.
Fabulous. Thanks, Isaiah. And Nettie, perhaps you could talk a bit more about the clients that you work with and the industries that they're in as well, and maybe comment on their willingness regarding the Nigerian judicial system.
Yeah, well, really, regardless of sector, in my experience, most of my clients almost certainly prefer, favor arbitration as the dispute resolution mechanism. US investors generally prefer to avoid litigation in local courts for varying reasons, including a desire to be in a tribunal that feels familiar, and perhaps also to avoid certain perceived inefficiencies that may plague local courts. However, it's not always completely possible to avoid the local courts, right? So assuming an investor is successful in arbitration offshore, you then need that arbitral award to be enforced by a local court. The fact that Nigeria is a party to the New York Convention and enforcement of arbitral awards is very attractive. It's a positive. But I can tell you that notwithstanding that fact, a good number of foreign investors are still have significant concern on the willingness of Nigerian courts to enforce arbitral awards in their favor. And in that regard, I guess I would be interested, Isaiah, in your thoughts on perhaps success rate of Nigerian courts awarding, enforcing arbitral awards in favor of foreign investors, in your experience.
Mm-hmm. Nandi, that's a very good question. I can see a question on that in the Q&A as well. So Tom mentioned the point of jurisdictions developing a reputation. And I think that might be the problem Nigeria has, in the sense that you will find a number of decisions that favor the enforcement of arbitration for foreign and domestic investors. So I'll give you an example. The Supreme Court has set the benchmark in the interface between arbitration and the courts as one that preserves the parties' autonomy to arbitrate their dispute and to minimize judicial intervention. And the Supreme Court is trying to develop this jurisprudence of a pro-enforcement bias. But with that, you have a series of other decisions that go the opposite way, where the courts seem a bit too willing to interfere. So for instance, the most recent example I can think of is an ICC award being set aside before the Nigerian courts on the grounds that one of the arbitrators failed to disclose a point which arguably was not on the it was not a point to be disclosed under the IBA rules of conflict. So I think what we need to do going forward, and there are a lot of steps to do this, is to make a concerted effort to develop the reputation of the jurisdiction as one that is pro-enforcement, and to increase the efficiency in terms of that interface between arbitration and the courts. Because you don't want, for instance, a situation where you've obtained an award quite efficiently, try to enforce that before the Nigerian courts, but then again have a number of years before your enforcement actually materializes. And in terms of what we're trying to do to improve that, again, in the arbitration and mediation bill, we are introducing a timetable for court proceedings. So if an arbitration application comes before a court, then there is a timetable within which the court should hear and dispose of that application. But in the side decisions that favor enforcement for foreign and domestic investors, the problem is those few decisions that seem to get all the attention where the court is leaning the other way, and that's what causes the uncertainty. That's what we really need to take care of in terms of building our reputation.
Great, thanks very much, Isaiah. And Tom, do you have any views on the enforcement in Africa. I ask you this specifically because in the Q&A, Talamina also asked you to address this question as well.
Yeah, I think Isaiah sort of hit the nail on the head. I think if you look at a lot of these jurisdictions, and not just in Africa, the same is true here in the UAE. You look at a lot of these jurisdictions, and the courts regularly and with some level of consistency will enforce foreign arbitral awards. But it's that handful of decisions where they get it wrong, and sometimes they get it wrong in a big way, that captures all of the attention. And to a great extent, dispute resolution is a game of reputation. If word gets out that there's a bad decision in a particular jurisdiction, that jurisdiction is going to have trouble maintaining its reputation as a safe seat for arbitration and dispute resolution. I think I think there are different ways that different jurisdictions can go about remedying this problem. Isaiah has noted some of the approaches they're taking in Nigeria, and it's not a one-size-fits-all solution. But here in the UAE, for example, the new, well, it's 2 years old now, but the new UAE Arbitration Act made the supervisory court the court of appeal rather than the court of first instance. So all arbitration-related applications go directly to the court of appeal, the higher court, the court that's used to dealing with legal and procedural issues rather than the facts. In the first instance, I think that's a positive development that other jurisdictions might look to. Now, Isaiah and I have had this discussion. I think there are some constitutional issues in Nigeria that may prevent that. Another good example, I think, is Mauritius. What Mauritius has done is made the supervisory court for arbitration-related matters a special chamber of judges within the Supreme Court of Mauritius, the highest court in the land. I don't know if it's 3 or 6 or 9 judges in this chamber that deal with all arbitration-related decisions. So there are ways you can go about this, but I think more broadly, it's important for the arbitration community to engage with the judges in the courts, talk through these issues, talk through ways of addressing these concerns. You go to a lot of arbitration conferences and there are no judges there. That needs to change. There has to be more dialogue, not just in Africa, but around the world.
That's a great point. Thanks, Tom. We've now had a number of other questions come in from the audience, and I do want to get to as many as possible, but I also want to look into technology and diversity within Nigeria. So I'll just select a couple more, and if we don't get to your questions, please do just email us afterwards. Next question is, do you consider the Lagos multi-door court provisions, which are replicated in many state jurisdictions, as institutional support for mediation and conciliation? Who would like to take first stab at that one? Isaiah?
Yes, absolutely. It's and the Lagos multi-door court is a very, very successful model that is being implemented in Lagos State. I'll give you an example. I was actually having a discussion with a colleague yesterday, and I asked what the average number of cases referred by the court to the multi-door court is for mediation. And on average, each month, about 70 cases are referred from the High Court to the multi-door courthouse. Let me just give some context as to what the multi-door courthouse does. It has something known as an A-track for mediation or for another ADR method. And if they find that your case is more suitable for ADR, it goes on that ADR track. And nevertheless, if it goes to the main court, the judge can still, in consultation with the parties, suggest that the case be transferred to the multi-door courthouse for mediation. And if a mediated settlement arises from those proceedings, then the parties can go back to the court and have that settlement become the consent judgment of the court, which makes it easier to enforce. So it's a really, really good model. Other states are trying to replicate it, but the Lagos model is one that works very well.
Well, that sounds like a great advancement given all the discussions that we've had around enforceability thus far on this webinar as well. And I'm just going to take one more audience question before we move into technology. And perhaps, Tom, this is a question for you. Question from Jane Lambert, I believe. Yes. China is investing very heavily in Africa as part of its Belt and Road Initiative. Disputes must arise from time to time between Chinese and African parties. Which forum do those parties use and which law governs?
That's a very good question. You're absolutely right. I mean, China has been investing heavily in Africa really for a decade and a half now. I think what's interesting about this question is, certainly based on my observations, discussions I've had with people, that is and look, I'm speaking in generalities here, but Chinese companies, especially state-owned companies, tend to be litigation and arbitration averse. They much prefer to resolve disputes through negotiations, mediation, settlement. And I think to date, that's how a lot of the disputes between Chinese and African parties have been resolved. Now, that may sound like a good way to resolve disputes, but I think there's some concern about that, especially from the perspective of African parties, because in a lot of these situations, in terms of bargaining power, the Chinese party is often in the stronger position, and so the negotiations often can favor the Chinese party. I think things are starting to change, though. I think there is a recognition that more of these disputes need to be resolved at more of an arm's length, in an arm's length situation by neutral third parties. So I think we are going to see an increase in the use of adversarial dispute resolution to resolve disputes between Chinese and African parties. And I think for the most part, going back to what Nettie said earlier, I think a lot of that's going to happen through arbitration rather than litigation. Of course, it's going to depend on the type of dispute. Labor disputes, yes, those are going to go to the court. Other types of disputes will as well. But I think your larger commercial disputes between Chinese and African parties will increasingly move to arbitration. Now, the next question, of course, and this ties to some bigger questions, is where are those arbitrations going to take place? Are they going to take place on the African continent? Are they going to take place in China? Are they going to take place in a neutral location? I think the jury is still out a little bit in that regard, but there has been some move. There has been a move between the Chinese government and African governments to establish dispute resolution channels, especially in the area of arbitration, in both Africa and China, specifically designed to resolve these Chinese-Africa disputes. And one good example is the China-Africa Joint Arbitration Center, which was set up in Johannesburg. And I think there are branches being set up in other jurisdictions as well. This is basically an arbitral institution and a set of rules specifically designed to address disputes between Chinese and African parties. And I think the last part of that question is what law will apply. I think that goes back to what's negotiated between the parties and where the arbitration is going to be seated.
Fabulous. Thanks so much, Tom. And I'd like to switch now, because we've had a few questions coming in on technology as well. And also in light of the outbreak of COVID-19, all businesses have been tested for their innovation, ingenuity, and adaptability. Can you maybe talk through how COVID-19 has accelerated changes in the legal sector in Africa? And then we can go more specifically into some of the underlying legal tech that is needed there, because we've had a few questions coming in from the audience. So Isaiah, perhaps you could give your view on the ground on what are some of the advancements you've seen in the African continent recently. I know you touched on some in your introduction.
I think what it's done is it's accelerated the realization that we haven't invested enough. I came across a UN study. It was from 2007 that surveyed what respondents thought was the the most problematic areas in terms of justice delivery. And interestingly, one of the highest response, I think it was 32%, I could be wrong, but it was the highest response, was the need to invest in court technology. Because when you look at the inefficiencies in filing processes, in terms of the way those proceedings are recorded, in terms of the way the cases are managed, you see where these inefficiencies tend to crop up. And it's becoming very relevant now that the courts simply haven't invested enough. And I think one of the outcomes of this, because it will be such a shame to waste a crisis, is that there will be a surge in investment in courtroom technology in terms of electronic filing, in terms of court automation, and in terms of the electronic exchange of documents. I think what we're seeing now really is the product of a failure to invest and the need to put more money and more investment in courtroom technology.
That's great. Thanks, Isaiah. And there was also a question that came in as what legal technologies are most needed in Africa. Usman, I hope that's answered your question, but let us know if it hasn't. One more question related to technology and transformation is transformation can be top-down or bottom-up. An example of the former, top-down, might be judicial capacity building initiatives. An example of the latter would be encouraging young lawyers to be interested in arbitration, to become young arbitrators, and to secure appointments. What thoughts does the panel have? Isaiah, I see you're unmuted, so would you like to start?
Yes, I would. I think that is an excellent question because it touches on diversity in a way, not gender diversity, but generational diversity. And I'll draw your attention to the 2018 SOAS Arbitration in Africa survey. In that survey, 85% of respondents found that domestic arbitration was growing in their jurisdictions, but only 41% of respondents said they had been involved in an arbitration in terms of sitting as an arbitrator. Now, the question that raises for me is whether a select few arbitrators are getting the majority of appointments. And if it is, then domestically, we're replicating the problem at an international level, i.e. a select few arbitrators getting the majority of appointments. In terms of how we address that, there are a lot of initiatives in Nigeria. So for instance, you have a lot of young members group. If I can mention some of the ICC, YAF, the CIAB, YMG, Young ICA, are interested in a lot of capacity building in terms of developing young arbitrators. And I know certain of these, certain institutions also have schemes, mentorship schemes between more experienced arbitrators and younger arbitrators in terms of building up capacity. The CIAB, for instance, if I can mention it, will automatically assign disputes below a certain level to qualified younger arbitrators. So if it's a low value dispute, then you go to the top of the pile if you're a younger arbitrator, but you have a demonstrable experience and expertise in that field. So I think it's an excellent question. It's one that we need to give more attention to in terms of building the capacity of young arbitrators. And if this was a physical event, I'm sure you would see the enthusiasm from younger practitioners in terms of questions they would be putting to the panelists, and in terms of attendance. There is a great hunger for learning in Africa. We see that in a lot of the events we do.
Thanks, Isaiah. I don't think we have age profiling on our audience members today, but they have certainly been very enthusiastic and engaged. Tom, did you want to comment on that question as well?
Yeah, first of all, Isaiah took a lot of the words right out of my mouth. First of all, I think it's an excellent question from Michael. I think the short answer is we need both, top down and bottom up transformation. But I agree with what Isaiah is saying. I think a lot of it's going to be bottom up, because when you go to arbitration conferences on the African continent, the rooms are always packed full, and I don't see any more engaging audiences anywhere in the world than I do at arbitration conferences in Africa. A lot of them are young people. They have good questions. They have a lot of questions. And I think that's just going to, I've seen it grown in the last 5 to 10 years, and I think it's only going to keep growing over time. But, by the same token, we need top-down investment as well, investment in technology. What I was referring to earlier, conversations between arbitration practitioners and the judiciary. The other thing I think, too, that occurs to me is that to tie some of these strings together, I think technology can help with diversity. You look at initiatives like arbitrator intelligence, which Professor Catherine Rogers is pushing, which is a sort of she can explain it much better than I can, but when an award is issued, certain objective data from that award goes into this database, and then people can retrieve information about different arbitrators. The whole idea is to make this information available to a wider audience so that the same small group of arbitrators isn't appointed over and over, so that people have access to information about a larger pool of arbitrators. So a young arbitrator based in Nairobi or Mombasa, after he or she has issued a couple of awards, it goes into this database and people have access to that objective information. I really think technology can help increase diversity, and diversity is so important in arbitration in particular, because the whole system is based on credibility and people's confidence in the system. And if we don't have diversity in terms of arbitrators and counsel, diversity in different respects, gender diversity, ethnic diversity, national diversity, the system's not going to work well. So I think these are very important issues, and I think technology can help.
That's great. Thanks, Tom. And yes, diversity of thought is extremely important. And I think that's one of the great things, about being in the UAE as well. It's a very diverse mix of genders and nationalities that we have here as well. We have so many more questions coming in from the audience. We are running out of time. One that has just come in, which I think is sort of a nice higher level one, is, does public policy play any role in enforcement mechanism? Would anyone like to take a shot at that?
I don't mind taking a shot at that. Public policy absolutely plays a role in enforcement mechanisms. You will find that in emerging markets in particular, in an arbitration context, if you have an award from the ICC or from London or Singapore, and you've got to now take that into Nigeria, or you've got to take that into the UAE, or you've got to take that into India, you will have a lot of difficulty at times enforcing that award, because the other side will raise the issue that it's against public policy. So in our experience, public policy has a tremendous impact on enforcement, and is often something that is used as a tactic to frustrate the enforcement efforts in an emerging jurisdiction.
Great, thanks so much for that, Dilip. Okay, we only have a couple of minutes left, so I am going to ask the audience one final polling question, and then we'll get the panelists to ask the final question as well before we wrap up. So the last question is, what would you consider to be the game changer in the future for you to select an African jurisdiction for dispute resolution? Is it enhanced technology across all aspects of dispute resolution, greater ease of enforcement of judgments and arbitral awards, more transparency, or faster resolution of disputes within the judicial system? And we unfortunately don't have an E, all of the above, because that might also be one option. So as the results are coming in, I would just like to say from my side, thank you all so much for your engagement today. As always, we've had so many questions coming in from you, which really does show that you've been engaged the entire webinar. We know that time is precious at the moment, so thank you so much for your engagement. And it looks as though we've had About 30 responses come in already, and does seem to be trending towards greater ease of enforcement of judgments and arbitral awards, which sort of ties into some of the themes that we've been discussing. So finally, I would just like to ask each panelist to give one prediction for what they see in the future with regards to your areas of expertise as it relates to Nigeria or Africa as a whole. So it can be as crazy a prediction as you like. We will not hold you to it. Isaiah, let's start with you.
Predictions, well, recommendation first and a prediction. So recommendation, I think for innovation and my wealth predictions to work, we also need to see a change in attitudes from the practitioners on our continent. I think that will go a long way. In terms of prediction, I think we're going to see a huge investment in technology from our courts, from the Supreme Court all the way down to the higher courts in the different jurisdictions. I think the technology will enhance the experience of litigators and clients alike, in the sense that if we reduce that face-to-face interface, face-to-face interaction between a lawyer and a court official, it decreases so many things: inefficiency, prevalence of corruption, efficiency, as I said before. So I think we're going to see a massive investment of technology in our court systems, which will increase the experience for domestic and international investors.
Fabulous. Thank you so much, Isaiah. Dilip, what is your prediction?
Well, you said you won't hold us to it, and we can be as creative as we like. So here's my prediction. Within 18 to 24 months, they will abolish the rule against champerty maintenance in Nigeria. One of Nedi's institutional clients will invest in our fund. Tom will bring me a case involving Nigerian parties, an arbitration claim that is seated in the ADGM Arbitration Center. We will win that award, and then we will have Isaiah help us on the enforcement in Nigeria. That's my prediction.
That sounded more like a wish list, but that's okay. I'll give you that one. Nedi, what's your prediction for the future with regards to your expertise in Nigeria and Africa as a whole?
Right. So as I said at the top of the hour, I assist foreign investors mainly with transactional diligence, right? So when they're looking at an opportunity or an investment target in Nigeria, I assist with evaluation of various types of risk, one of which includes corruption risk. And my prediction and fervent wish as a Nigerian, as an American, is that at some point in the future, corruption risk will be deleted from the list of significant hindrances to the very much needed, I think, flow of foreign investment to African countries. So that's my wish and prediction.
Brilliant. Thank you so much, Nedi. And Tom, to close with you.
So I think I'm going to go back to what I said at the top of the hour too. I think we're seeing a number of jurisdictions moving in a very good direction when it comes to arbitration and emerging as go-to seats. I think it will take some time for this to happen, but I think within 10 to 15 years, you'll see an African jurisdiction that is known as an arbitral seat on par with established seats like New York, London, Paris, Singapore. And I think it will come down to, and I'm going to be in trouble with Isaiah and my friends in Kenya and elsewhere, but I think it's going to come down to Kigali and Mauritius, and I think Kigali will edge out Mauritius.
Excellent. Thank you so much, Tom. So we have some nice sort of one or two look forward there and a little bit further. So I say we all come back together every year to discuss this, and hopefully next time we can do it in person in Lagos. So on that, just from my side, thank you so much. Fabulous panelists. It's been great having this discussion. Thank you to the audience. And I'd just like to hand back over to Linda to close out the session.
Rachel, thank you so much. And as always, fabulously moderated. Thank you so much for that. It's been a brilliant session. To our panelists, Nettie, Dilip, Isaiah, and Tom, that was a really insightful discussion. And I think being able to answer the audience's questions was absolutely terrific. So you brought an extraordinary level of depth to this discussion. I think we've now developed another theme in our third edition. So we started in Mumbai with litigation funding dominating. Mediation, alternative dispute resolution seemed to be what was in Riyadh. And enforcement, I think, has kind of dominated here in Lagos. So it's really interesting as we go across the world, we see these themes as to what's resonating in the market. So for our emerging markets, those three are really interesting. Our next three destinations are New York, London, and then home to Abu Dhabi at the end of the year. So you've been an amazing audience. Thank you very much for participating in this with us. We really do appreciate your questions and the interactivity, because that's what makes this knowledge series really successful and enduring. And that's what we want. From the ADGM Arbitration Center to our partner Phoenix Advisors, Dilip, thank you very much as always for the support on this, and for our team AIM Films. They're extraordinary for bringing this together. So we look forward to seeing you in New York. You will hear something about us about that shortly. But thank you very much. Have a good evening, have a good morning, have a good afternoon wherever you are, and we look forward to seeing you again shortly. Thank you.